These are definitely in the crosshairs of the government. We are the Armed Attorneys. We have an exciting discussion today as it relates to suppressors. Now, we have a new open letter from the ATF talking about what's in their crosshairs. Is this a change in policy? Have they been doing this for a while? They cite some cases. Do those cases even hold water? But we're going to be talking about all of that. But before we begin, show your support for the Second Amendment by hitting that like button. And Emily is out making the bacon today. She's in court, so you got me, but we have a lot of fun things to talk about. And today's video is brought to you by friends over at Sonoran Desert Institute. If you're thinking about, hey, I need to probably improve my gunsmithing knowledge, Sonoran Desert Institute is an online accredited university where you can take your skills to the next level. Check them out at sdi.edu/armed-attorneys. Now, today's topic was brought to you by a friend of the show, Andy. Andy, you know who you are. And the ATF published this letter on November the 20th, 2023. And essentially they are talking about, or, giving their official stance on solvent traps. Now, for the past couple of years, the ATF has already been cracking down on these things as saying these things are completed suppressors, And the context that this would come up in is I would have a client who'd say, hey, I want to form one. I would like to build an NFA item. I'd like to make my own suppressor. And they would go on Facebook, Marketplace, or these other kind of less than ideal websites and purchase what was called a solvent trap. Now, these things are marketed as being a tool to help somebody clean their firearm. Now, I'm interested to see what y'all have to say in the comment section below. Can it actually be used for that purpose? I'm hearing conflicting stories about that. But what they were doing is they were taking these solvent traps, which were completely enclosed, no holes in it, and saying, hey, ATF, I would like to turn this into a suppressor. I would like to form one, make this, serialize it, get your pre-approval. And there's a short period of time where the ATF was like, sure, no problem. And then abruptly, and without kind of any guidance on the topic, they started saying, no, we consider this a completed suppressor, and therefore you can't make it into a suppressor. It's already a suppressor. And so they started denying those applications. Now, that had been going on for quite some time, but we just got this letter from the ATF providing their official position on solvent traps. I wanted to go through it. There's some things to look at here, and I'm going to dive into one of the cases that they cite because I think it gives us some guidance on what they are looking for when they are investigating somebody for unlawfully possessing an unregistered suppressor. So let's kind of go through this letter a little bit. Like I said, it was published on November the 20th, 2023. And here they say the Bureau of Alcohol, Tobacco, and Firearms and Explosives recently examined devices commonly marketed as solvent traps and determined that some of them are firearm silencers as defined by the Gun Control Act and the National Firearms Act. Solvent traps are marketed devices to attach to firearms barrels to catch excess solvent used when cleaning the firearm. The ATF has not, that's their emphasis, clarified that has classified any devices as solvent traps because the term does not exist in relevant statutes or implementing regulations. However, the ATF has, their emphasis, classified numerous devices as firearm silencers, even though they are marketed as solvent traps. The test for whether an item is a silencer is not the label the manufacturer or retailer applies. Rather, it is the way the statute is written by the Congress as applied to the item. Both the Gun Control Act and the National Firearms Act regulate firearm silencers. The term firearm muffler or firearm silencer is defined in 18 U.S.C. 921A subsection 25 and 26 U.S.C. section 5845A subsection 7, that's tax code, as any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or a firearm muffler, and any part intended and only used for such assembly or fabrication. Some of the devices commonly marketed as solvent traps have been determined to meet the definition of firearm silencer because they have the objective design features and characteristics indicating that the device is, quote, for reducing the report of a portable firearm. Although solvent traps are generally marketed as having intended for other use as a silencer, e.g., filtering firearm cleaning solvent that is not determinative under the statute, ATF must consider a device's objective design features, including the use of which is a part capable, as part of the inquiry into whether a device is a firearm silencer. They cite Sig Sauer versus Brandon. For example, holes or marks indicating where holes should be drilled that allows the passage of a projectile to clear indicates that the device or components may be properly classified as firearm silencers, because this allows the propellant gases to expand and cool. By contrast, Holes serve no purpose in collecting solvent or debris and is actually contrary to the purported use of solvent traps. I'm sure. Is that true? I don't have a solvent trap. I haven't used these things before, but I'm wondering if these actually serve a purpose, kind of like we talked about earlier. All right, back to the letter. In the presence of indexing marks to drill a hole is not a prerequisite to classification as a firearm silencer. It merely is example of such evidence. That's important. Other such characteristics may include baffles, spaces, ported inner sleeve or tube, expansion chamber, end caps, and dampening material, depending on the particular design of the device. While increasing the effectiveness of a firearm silencer, these same objective design features offer no advantages in collecting or filtering cleaning solvent. And they got pictures here that they say makes it clear that these things are suppressors. Over the years, many companies involved in marketing solvent traps have asserted that they are permitted to manufacture, transport, or import these devices because they are not yet complete and therefore do not qualify as firearm silencers under federal law. However, this assertion is incorrect because a component of a firearm silencer need not be fully functional before it is recognized as a part intended only for use, end quote, in assembling or fabricating a firearm silencer. In fact, Congress explicitly chose to regulate a combination of parts intended for use in assembling or fabricating a firearm silencer and, quote, any part intended only for use, quote, in assembling or fabricating a firearm silencer. They cite 18 U.S.C. 921A, subsection 25. That's their definition there. Accordingly, a firearm part intended only for use in assembling or fabricating a firearm silencer is itself regulated as a firearm muffler or firearm silencer under both the Gun Control Act and the National Firearms Act. For example, a silencer end cap falls under the federal definition of a firearm silencer or firearm muffler, 18 U.S.C. 924. I think that's a typo. Fact check me. Does 18 U.S.C. 924A subsection 25 exist? And therefore is regulated as a silencer under the Gun Control Act and National Firearms Act, even when the silencer end cap is individually sold and transferred and not installed as a component of a silencer. Therefore, the importation, manufacture, and transfer of such silencers must comply with provisions of the Gun Control Act and the National Firearms Act. And this is what I think is probably the most interesting part. Furthermore, federal courts have held a device can be a silencer for purposes of 18 U.S.C. 921A, subsection 25, even if it is not operable in its current state. These courts have held that federal statute does not limit the definition of a silencer to a, quote, device that silences or muffles or diminishes. They cite Carter here, they cite Rose here, they cite Rogers here, and Silverson. This is consistent with Congress's intention to regulate all devices designed and intended to be used as silencers and not just those devices that are currently in a completed state, such that they will reduce the report of a firearm when attached. So then they go through the manufacturer's capability, or how they have to register these things. I don't think we need to talk about all that. Now, what do we generally say about open letters from the ATF? Well, they're kind of worth the paper that they're written on. The ATF issues opinions all the time and then secretly goes and changes their minds about things. These are not admissible in court. And so if somebody was operating under, let's say the open letter said, hey, these solvent traps are great. I don't think that would mean, or green light, because let's say they find you with one of these things, they would still possibly prosecute you when you're like, hey, look, you wrote this open letter saying, hey, I didn't break the law. They'd say, oh, sorry, that is too bad for you. So, be skeptical of open letters. All right, the thing that I think is most significant about this is the cases that they cite here. We'll talk about the United States v. Carter case. Now, in this case, we have a guy pulled over in a car, had some firearms. They search his house. They find some what they call machine gun parts. They find what they think is a suppressor. And here he had a tube. It had some like steel wool in it. It had holes in it. It was threaded in order to attach to a barrel. But the government's own expert in this case, he said that it wouldn't work. And so we look at what the ATF is saying here, and it's not whether it would work or not. It doesn't have to be a completed suppressor or silencer or muffler. It just has to be the intent of how you use it. Now, the government expert says this thing is not operable. And so they have to find a different way around to get to the definition that we have in this case. And they use the defendant's own testimony. So our lesson here is don't talk to the cops. All right. Because in this case, the defendant said that he was interested in silencers and researched how they work from He talked to his neighbor about it. He told his neighbor he was trying to make a suppressor, and he even testified that he had tried to fire a blank through the cylinder and it, quote unquote, didn't work too well. This is out of the Sixth Circuit Court of Appeals, and the government is relying on 2 circuits out of all of our circuits to say, hey, look, the federal courts back us up on this one. And to an extent, I would say they are right here. Just like we have with machine guns, where a combination of parts or having a part that's exclusive to be used in a machine gun, that could be a machine gun in and of itself. It's hot lava, as Emily likes to say. This is one of those things where we have similar definition for suppressors. So this combination of parts are a part exclusively for use in a firearm suppressor. That's where you could really get into hot water. But keep in mind, these are old cases. These cases are from 2006, 2008, 2001, 1996. Those are the cases that the government cites. So a lot of time has passed, and it's not like the authority goes away. It becomes less binding authority, but it becomes less relevant as time goes on. Especially, we have New York State Rifle and Pistol Association. We have a handful of more gun cases coming down the pike that might change the analysis here from a court in invalidating the NFA. Now, does this violate the Administrative Procedures Act? Have they just gone about and changed their rule without giving anybody the proper notice and comment period and implementing the rule? I don't know the answer to that. I honestly don't know the answer to that, because they aren't changing what they consider a firearm suppressor or firearm muffler. They're saying we're applying our existing definition. However, we've seen these type of arguments made with FRTs unsuccessfully by the government, by the way. The government said, hey, we didn't change our mind on, FRTs being machine guns. We say these fall under the existing definition. And there the courts have struck those down. So I don't know if we're going to see something on that front. But I think the important thing to take away here is these are definitely in the crosshairs of the government. Possessing a combination of these parts are just, they said here, a cap, for a suppressor. We're going to consider that thing a suppressor, and we're going to consider it unlawful. So just be extremely careful when looking at these types of things. I've also heard horror stories where, these online retailers, somebody throws up, they get a batch of these things from China, they throw up a Facebook ad, with all kind of couched language to make it seem inconspicuous. Well, the ATF and the federal government, they monitor that stuff. And they hit those people, they get their customer list, and they go out and they collect these things. So be extremely careful. And then I think the lesson from this is, they have to prove intent, right? And how do we prove intent in criminal cases? Well, a couple of different ways. We can see it by manifesting our actions, but a lot of times, the government doesn't have a mind reader. They can't get into your head and figure out exactly what you're thinking. And so these statements to law enforcement, statements to neighbors, we see a lot of people sinking their own ships a lot of times with statements that they make. So anytime you're interacting with law enforcement, invoke your right to remain silent, and then exercise it. Actually remain silent. And invoke your right to an attorney. Say, I want to speak to my attorney. I'm not going to speak to you without an attorney. And then hold firm to that. Now, there's a lot here. I'm interested to see what questions y'all have about this topic, but I hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And as always, we appreciate your questions and comments in the section down below. And until next time, we're the Armed Attorneys.